Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law.
People v. Anthony Blue, decided October 22, 2024. Halligan, J. Defendant Anthony Blue challenges his criminal conviction for 5 counts of second-degree burglary. Blue argues that a criminal defendant cannot make a knowing, voluntary, and intelligent waiver of the right to counsel unless the trial judge specifically apprises the defendant of his maximum sentencing exposure in years. Rather than imposing a bright-line rule such as this, we have said that a court must ensure a defendant is adequately warned of the dangers and disadvantages of self-representation before allowing him to proceed pro se. A review of the record here confirms that Blue had such an understanding at the time he waived his right to counsel. Blue also argues that his indictment should have been dismissed on statutory speedy trial grounds. CPL 30.30, 4d, broadly speaking, excludes from the time chargeable to the people a reasonable period of delay when a defendant is joined for trial with a co-defendant. Blue contends this provision does not apply to pre-arraignment time, but the appellate division correctly concluded that it does. Thus the 57 days between indictment and arraignment chargeable to Blue's co-defendant were also chargeable to Blue, even though he had not yet been arraigned. For these reasons, we affirm the order of the appellate division. 1. We recount only the facts essential to the issues before us. On March 25, 2013, a grand jury returned a single indictment charging Blue and his co-defendant Carnona Pueyo with 6 counts of second-degree burglary, see Penal Law Section 140.25, 2, arising from a series of burglaries in the Washington Heights area of Manhattan. Blue and Pueyo previously had been arrested on August 27, 2012, but that case was dismissed and Blue was released. At some point between his release and the arraignment on the indictment that was scheduled for March 28, 2013, Blue traveled from New York to Florida. He did not appear for arraignment at the scheduled time, but Pueyo did. On April 17, 2013, Pueyo requested a motion schedule, and the court, after an extension, set June 26, 2013 as its date of decision. After law enforcement located and apprehended Blue in Florida, he appeared for arraignment on June 13, 2013, 80 days after his indictment and 57 days after Pueyo's request for an adjournment. Blue was represented by court-appointed counsel when he appeared for arraignment, but by early 2014 he asked the trial court to proceed pro se. The court first addressed Blue's motion at an appearance on January 8, 2014. It advised Blue that waiving his right to counsel would be a big mistake because he faced a lot of jail time. Blue persisted in his request, and the court reiterated that he was making a mistake, asked him to think more about his decision, and decided to hold the motion over until Blue's next appearance. When Blue next appeared on February 3, 2014, he insisted that he still wanted to waive his right to counsel. The trial court engaged Blue in a colloquy to determine whether his waiver was knowing, voluntary, and intelligent. It explained, among other things, the nature of the charges against Blue and the dangers and disadvantages of representing oneself in a criminal proceeding. Blue stated that he understood the consequences of his decision. Specifically, he confirmed that he understood that many pro se representations are not successful, that he would be held to the same legal standards as an attorney, that he would be foregoing the benefits of courtroom experience and legal training possessed by his court-appointed attorney, and that he believed he was capable of representing himself in this case. On the last point, Blue informed the court that he had been involved in the criminal justice system before, and that he had read a criminal advocacy law book and been in debate classes. The court also explained to Blue that he was entitled to standby counsel, but Blue waived that right too, stating, "I'm positive. I waive standby counsel also." Following this colloquy, the court was satisfied that Blue's request was unequivocal and that his decision to give up his right to be represented by a lawyer was knowingly and intelligently made. It then granted Blue's request to proceed pro se. Over the course of the proceedings, Blue filed several motions to dismiss the indictment on statutory speedy trial grounds. Relevant here is Blue's first motion, filed on April 8, 2014, in which he argued that all the time between March 25, 2013, to June 13, 2013, is chargeable to the people because he was never notified of the proceedings and could not have voluntarily absented himself from a hearing for which he was not informed. The people responded that the entire period should be excluded from the speedy trial calculation under CPL 30.30, CI, because Blue fled to Florida after learning he had been indicted. Blue denied this allegation, insisting that he had no knowledge of the indictment when he left New York. Supreme Court denied Blue's motion. It acknowledged the factual dispute over whether Blue left the state to avoid apprehension, but concluded that there was no need to resolve it. Instead, relying on CPL 30.30, the court found that Blue's speedy trial clock stopped on April 17, 2013, when Pueo asked for an adjournment to file pre-trial motions. Because Pueo had not requested motion practice until 23 days after the indictment was filed, the court concluded that at most 23 days of the 80-day period between Blue's indictment and arraignment would be chargeable to the people. In that order, Supreme Court also determined that an additional 70 days were chargeable to the people on other grounds. That brought the speedy trial clock up only to 93 days, far short of the 6-month limit that would require dismissal. A year later, Blue filed another motion to dismiss pursuant to CPL 30.30. He argued that certain periods subsequent to his earlier motions were chargeable and reiterated his position that the period from March 25, 2013 to June 13, 2013 was chargeable as well. Supreme Court agreed that some additional periods of time postdating its earlier order were chargeable to the people, and further found that, even assuming the entire 80-day period between Blue's indictment and arraignment was chargeable, no more than 174 days are chargeable to the people. The court therefore denied that motion as well. The case proceeded to trial, and a jury found Blue guilty on 5 of the 6 counts. Supreme Court sentenced Blue to consecutive terms amounting to 25 years in prison followed by 5 years of post-release supervision. Blue appealed the judgment as well as the subsequent denial of his CPL 440 motion, which was based, among other things, on the alleged CPL 30.30 violation. On the speedy trial issue, the appellate division rejected Blue's contention that the entire period between his indictment and arraignment was chargeable to the people, but agreed that the period from March 25, 2013 to April 17, 2013 was chargeable. The court also found that the trial court had improperly excluded an unrelated 12-day period in November 2014. Those determinations, taken together, brought the amount of time chargeable to the people to only 180 days, and accordingly the appellate division agreed that Blue's motion to dismiss the indictment should be denied. The appellate division also rejected Blue's argument, made for the first time on appeal, that the trial court should have suppressed text messages obtained pursuant to a warrant to search his cell phone because the warrant was executed more than 10 days after the date of issuance, and, according to Blue, thus violated CPL 690.30. The appellate division determined there was no statutory violation and affirmed the conviction. A judge of this court granted Blue leave to appeal. 2. We begin with Blue's challenge to the validity of his waiver of his constitutional right to counsel. It is well established that a defendant may choose to proceed pro se, see People v. McIntyre, for Etta v. California. Because this decision requires a disavowal of the constitutional right to counsel and the many benefits associated with legal representation, a defendant must make a knowing, voluntary and intelligent waiver of that right. People v. Arroyo. A trial court must undertake a searching inquiry in assessing whether a defendant's waiver meets this standard. People v. Providence. That inquiry encompasses consideration of a defendant's pedigree since such factors as age, level of education, occupation and previous exposure to the legal system may bear on a waiver's validity. People v. Cramp. Furthermore, it must be aimed at ensuring that the defendant is aware of the dangers and disadvantages of proceeding without counsel. See also People v. Vivencio. As the U.S. Supreme Court put it, a trial court must assure itself that the defendant knows what he is doing and his choice is made with eyes open. Ferretta, quoting Adams v. United States ex rel. McCann. Mindful that there is simply no one-size-fits-all format for a searching inquiry, Cramp, We have eschewed application of any rigid formula and endorsed the use of a non-formalistic, flexible inquiry, arroyo. We have required that the colloquy adequately warn a defendant of the risks inherent in proceeding pro se, and apprise a defendant of the singular importance of the lawyer in the adversarial system of adjudication, People v. Smith. When a defendant challenges the validity of their waiver on appeal, a reviewing court may look to the whole record, not simply to the questions asked and answers given during a waiver colloquy, to determine whether the defendant effectively waived counsel. In reviewing the record, the critical consideration is defendant's knowledge at the point in time when he first waived his right to counsel, cramp. Although post-colloquy proceedings cannot retrospectively cure an invalid waiver, the record as a whole may be considered when a court assesses whether the accused was aware of the dangers of self-representation at the time of the waiver colloquy. Blue argues that his waiver was deficient in only one respect: the trial court did not expressly lay out during the waiver colloquy the range of allowable punishments, including the maximum number of years of potential imprisonment, that Blue might face if convicted. That position finds support in at least one decision from the First Department, which held that the trial court was required to inform a defendant during the colloquy of their actual sentencing exposure, see People v. Rodriguez, but see People v. Rogers, declining to follow Rodriguez. But neither this court nor the U.S. Supreme Court have required a specific recitation of maximum potential years of imprisonment as part of a valid waiver colloquy. To the contrary, we have declined to impose particularized requirements of this sort upon a trial court, instead instructing that the inquiry is flexible and should be aimed at achieving the goals outlined above. See, for example, Providence, Arroyo, Smith, see also Ferretta. None of the cases Blue and the dissent Marshall hold otherwise. In Von Moltke v. Gillies, a plurality of the U.S. Supreme Court emphasized that the validity of the waiver turns on the circumstances surrounding it. There, the defendant, the wife of an alleged German spy who was told only that she was being held indefinitely as a dangerous enemy alien, was briefly assigned an attorney who agreed to represent her for only 2 or 3 minutes at arraignment, but she otherwise had no legal counsel upon whom to rely except the government lawyer agents who would prosecute her case. Throughout the proceedings, the defendant gave no indication that she was aware a sentence of death could be imposed under the charges. Witness testimony revealed the defendant's perplexity, doubt, and uncertainty leading up to her decision to plead guilty, and the record revealed no explanation of the implications of the indictment or of the consequences of her plea. On those facts, the plurality found her waiver of counsel invalid and noted that information essential to a defendant's broad understanding of the whole matter included an apprehension of the nature of the charges, the statutory offenses included within them, the range of allowable punishments thereunder, and possible defenses to the charges and circumstances in mitigation thereof. Our analysis in matter of Lawrence S. was along similar lines. We noted that the case involved a 13-year-old respondent, and that with respect to a juvenile charged as a delinquent, the courts have imposed particularly strict requirements before permitting a waiver of his right to counsel. We found the waiver invalid not because the court failed to make any particular statement during the colloquy regarding the potential years of imprisonment faced by the defendant, but because the court's inquiry did not sufficiently account for the youth and inexperience of the defendant. Nor does Iowa v. Tovar mandate that a colloquy include any specific, formulaic statements regarding the precise number of years of incarceration a defendant might face. In Tovar, the U.S. Supreme Court unanimously reversed a state court decision requiring trial courts to give specific warnings to a defendant during a waiver colloquy. The court found the colloquy at issue sufficient even without these warnings because the defendant was informed of the charges against him, his right to counsel, and the range of allowable punishments. While finding those factors relevant, the court did not hold it constitutionally necessary to provide each of those 3 specific items of information during a colloquy. Indeed, the court stressed that it has never prescribed any formula or script to be read to a defendant during a colloquy, and that its decisions indicate that the information a defendant must possess in order to make an intelligent election, will depend on a range of case-specific factors. Thus, as we previously have explained, Tovar reaffirms that the scope of a searching inquiry turns on the context in which the right to counsel is waived, rather than declaring a new rule for assessing the validity of a waiver. Cramp, citing and discussing Tovar. The question before us, then, is whether Blue was adequately warned of the dangers of proceeding pro se when he waived his right to counsel. Our review of the whole record satisfies us that he was. The proceedings prior to the colloquy establish that Blue was aware that he likely would serve a lengthy prison sentence if convicted. At arraignment, the people informed the court in Blue's presence that the defendant is charged with 6 violent felonies and faces substantial time. Then, while conversing with the defense counsel, the court explained that the defendant faces a mandatory state prison sentence and could get consecutive sentences. He is clearly facing a lot of time. That remark prompted the people to clarify the sentence they would seek. The people in this case are recommending 12 years jail with 5 years post-release supervision. Later, on January 8, 2014, when the court first addressed Blue's motion to proceed pro se, Blue explicitly stated that he understood he might serve a significant sentence. The defendant, I still would like to waive counsel and proceed pro se. The court, that's a big mistake. You face a lot of jail time. The defendant, I understand, Your Honor, but I am making my decision. The court, it's a big mistake. The defendant, so what is the decision for the pro se? The court, I want you to think about that. That's a mistake. I am going to ask you a lot of questions on February 3rd. The defendant, I understand. In light of these exchanges during pre-colloquy proceedings, it is clear that Blue had an understanding of the extent of his potential sentencing exposure by the time the trial court conducted its waiver inquiry on February 3, 2014. Then, during the colloquy, Blue informed the court that he had been through a trial before and that he understood he was charged with burglary, in the second degree. He also told the court that he had discussed a potential plea bargain, what he called a cop-out, and the strength of the people's evidence with his court-appointed attorney, indicating that he understood he faced an even longer sentence than the 12 years of imprisonment and 5 years of post-release supervision that the people sought. Nothing in the post-colloquy proceedings suggests Blue did not apprehend the extent of his potential sentencing exposure. During an appearance on September 29, 2014, the court noted that Blue's exposure in this case is huge and that he could go to jail for 25, 30, or 40 years, to which Blue replied that he was aware and understood. The court later informed Blue, during discussion of a possible plea, that his exposure was way beyond 5 years, and Blue said, I'm fully aware of it. I'm fully aware. These proceedings confirm what was apparent from the pre-colloquy proceedings. Blue had an understanding of the extent of his potential sentencing exposure at the time he elected to waive his right to counsel. We thus find his waiver valid. 3. We turn now to Blue's statutory speedy trial claim. CPL 30.30 requires that the people be ready for trial within specific time periods that vary according to the level of offense charged, People v. Bay. The failure to declare readiness within the statutory time limit will result in dismissal of the prosecution, unless the people can demonstrate that certain time periods should be excluded, People v. Price. When, as here, a defendant is charged with a felony, CPL 30.30, 1a, requires the people to be ready for trial within 6 months of the commencement of the criminal action. The parties agree that the people were required to declare readiness within 184 days, and that the appellate division properly charged 180 days to the people. They dispute whether the 57-day period from April 17, 2013, when Blue adjourned for motion practice, and June 13, 2013, when Blue was arraigned, should be excluded pursuant to CPL 30.30, 4d. The appellate division concluded that the period is not chargeable to the people. We agree. When resolving a question of statutory interpretation, the primary consideration is to ascertain and give effect to the legislature's intent, People v. Schneider. As the clearest indicator of legislative intent, the starting point in any case of interpretation must always be the language itself, giving effect to the plain meaning thereof, People v. Golo. CPL 30.30, 4d, provides that the following period must be excluded from the speedy trial clock: a reasonable period of delay when the defendant is joined for trial with a co-defendant as to whom the time for trial pursuant to this section has not run and good cause is not shown for granting a severance. The question before us is when a defendant is joined for trial with a co-defendant, prior to arraignment, or, In cases where the defendant is not arraigned at the same time as his co-defendants, only afterwards. The answer to that question is supplied by CPL 200.40, which sets forth the three basic situations in which two or more defendants may be joined for trial. Peter Pricer, Practice Commentaries, McKinney's Cons Laws of NY, CPL 200.40. As relevant here, CPL 200.40, 1a, states that two or more defendants may be jointly charged in a single indictment provided that all such defendants are jointly charged with every offense alleged therein. Blue and Pueo were jointly charged in a single indictment with every offense alleged therein, and so Blue was joined for trial with his co-defendant at the time of indictment, prior to his arraignment, for purposes of CPL 30.30, 4d. This interpretation is consistent with the purposes underlying the exclusion. We long have recognized that in the state of New York, a strong public policy favors joinder, because it expedites the judicial process, reduces court congestion, and avoids the necessity of recalling witnesses. People v. Mahboubian. CPL 30.30, 4d, furthers that policy by facilitating joint proceedings, easing the administration of multi-defendant cases, and preventing defendants from benefiting from delays caused by co-defendants who might, for example, make successive requests for adjournments. See People v. Chrysler. We note that the federal courts have inferred the same purposes from near identical statutory language. See, for example, United States v. Pena. Blue argues that a defendant nonetheless cannot be joined for trial for purposes of CPL 30.30, 4d, until they have been arraigned. Arraignment confers jurisdiction over a defendant, see People v. England, and triggers various rights under the criminal procedure law, see CPL 210.15, 1, 2. But these points do not necessarily compel the reading of CPL 30.30, 4d, that Blue advances. As an initial matter, the text of the provision does not differentiate between pre- and post-arraignment time. And we previously have recognized that the people may declare readiness before a defendant is arraigned and that certain pre-arraignment delays not attributable to the people may be excluded from the speedy trial clock. See, for example, People v. Carter, confirming that time is not chargeable to the people simply because no court has jurisdiction over the criminal action and the defendant's rights have not yet attached under the criminal procedure law. In the same vein, Blue argues that if the legislature had intended for the exclusion to apply before arraignment, then it would have expressly said as much. He suggests that we should infer from the absence of a clear statement applying the exclusion to pre-arraignment time that it applies only to post-arraignment time. The statutory scheme refutes the premise of this argument. Looking to the rest of CPL 30.30, we note that another provision distinguishes between pre- and post-arraignment time. See CPL 30.30, 4i. That express textual distinction shows that the legislature knew how to draft an exclusion that applies only to pre- or post-arraignment time, but did not do so on CPL 30.30, 4d. Blue also argues that the provision's reference to severance implicitly limits CPL 30.30, 4d, to post-arraignment time. The provision does not apply unless good cause is not shown for granting a severance, CPL 30.30, 4d. Blue notes that severance is a remedy ordinarily available to a defendant only after they have been arraigned, see CPL 255.20, 1, and argues that it would not make sense for CPL 30.30, 4d, to apply before arraignment, when a defendant cannot sever their proceedings. We disagree. When the people seek to exclude time pursuant to CPL 30.30, 4d, a defendant may make a showing of good cause severance not necessarily to sever the joint proceedings, but instead to charge that period of time to the people. Some defendants might wish only to charge additional time to the people, without actually severing the joint proceedings. And as at least one appellate division has recognized, the exclusion allows a defendant to show that he would have had good cause to sever at some earlier time, see People v. Vidal. Next, Blue argues that his interpretation of CPL 30.30, 4d, better reflects the purposes of the exclusion. He concedes that the exclusion is intended to prevent defendants from causing delays that inure to the benefit of co-defendants, but says that a defendant cannot engage in this kind of gamesmanship until after they have been arraigned, precisely because they cannot file pretrial motions until that point. See CPL 255.20(1). That may be so, but a co-defendant, if arraigned, can still participate in that kind of gamesmanship. Further, Blue cannot square his interpretation with the other purposes of the provision, namely, to facilitate joint proceedings and ease administration of multi-defendant cases. His interpretation would force the people to undertake the difficult task of maintaining a separate speedy trial clock for each defendant in a joint proceeding, which might in turn necessitate separate trials, an outcome that would undermine a key purpose of the exclusion. Finally, Blue argues that even if a defendant can be joined for trial with a co-defendant before he is arraigned, charging pre-arraignment time to the defendant would conflict with the statutory language that restricts exclusions to a reasonable period of delay, CPL 30.30(4)(d). According to Blue, it would be unreasonable to charge time to a defendant before a court has jurisdiction and before their rights under the criminal procedure law have attached. But, as we have said, pre-arraignment delays not caused by the people may be charged to a defendant, see Carter, and Blue has not shown that charging Pueyo's pre-arraignment delay to him is unreasonable. In sum, we conclude that the Appellate Division properly excluded from the speedy trial calculation the 57-day period between Pueyo's request to adjourn and Blue's arraignment. That leaves the speedy trial clock at 180 days, 4 fewer than the maximum number of days to which the people are statutorily entitled. 4. Blue's remaining challenges are unpreserved or meritless. He argues that he is entitled to a new trial because text messages taken from his cell phone were improperly admitted into evidence in violation of CPL 690.30(1), which governs the execution of search warrants. This argument is unpreserved. In supplemental pro se briefing, Blue also presents 2 additional statutory speedy trial claims. The first of these remaining arguments is not sufficiently developed to establish a basis for reversal, and the second is belied by the record. The order of the Appellate Division should be affirmed. Order affirmed. Opinion by Judge Halligan. Chief Judge Wilson and Judges Garcia, Singas, Canataro and Troutman concur. Judge Rivera dissents in an opinion. Decided October 22, 2024.
Decision podcasts are brought to you by the New York Prosecutors Training Institute. Find this and other decisions at NYPTI Law. www.nypti.org/law